Welcome to Make It Last, helping you keep your legal ducks in a row and your nest egg secure, with your host, Victor Medina, an estate planning and elder law attorney and certified financial planner.
Hey everybody, welcome back to Make It Last. I'm your host, Victor Medina. I'm so happy you've joined us here this Saturday morning if you're listening live or if you've subscribed on our podcast, wherever you are, whenever you're listening to this show. I am excited for this show because we're going to be talking about one of my favorite subjects, which is how can you protect an inheritance when you pass away. Turns out that most of the time people come and see me in my day job as an estate planning attorney. It's largely to make sure that the inheritance that they leave behind is protected from creditors, from divorce, from other threats like that. So we're going to talk about that in the next couple of segments, in segment 2 and 3. But before we get there actually is some new news that I want to share with you about a new law that has passed. And it is one of the most modern things that we've seen come across in the most archaic area of law for different kinds of estate planning. Now, you've heard me rant and rave in prior shows about why you're supposed to have your power of attorney. Remember, that's the document that helps you helps you grant somebody the ability to manage your assets. So if you become incapacitated, if you can't manage your stuff, the power of attorney helps that person do that. And so it's really important to have one. That's the first thing. Have a good one. Have one that's recently signed. And so many people that I encounter come in having signed a power of attorney, but it's from decades ago. I mean, it's not even close to the century. I normally ask people, I said, when's the last time you've updated your estate plan? Because if it's been more than 10 years, that's still in the 21st century, but it's been a long time to do that. So these powers of attorney, they're essential documents because we don't know when or if we're going to become incapacitated, and we don't know what's going to what the landscape's going to be like then. What will we own? What will we need to access? So the power of attorney not only should be signed, but it should be regularly updated. And so the new law that came into place is it's perfect for this whole discussion of where we are today, which is that almost everybody that I meet, from kids to their grandparents, has some form of a social media account. I still have I have a Facebook account. I have a Twitter account, and my son, who's 13, has 3 other things that I've never heard of, and that's how he talks to his friends, because he's really not going to he's not going to be on the same platform as his dad. There's just no chance that he can't stay cool if he's on the same platform as me. So I've gone ahead and I've snuck on to Instagram, and I got very flattered when he decided to follow me. And then in addition to following me, he liked some of my photographs. You don't know what kind of joy it will bring you to see a little red heart underneath the photograph that you've posted that your son has liked. So anyway, he's got those different social media accounts. But there are tons that are out there. And in fact, so much of our life is led these days on the internet. It's how we have connections with people. Well, back in the day with the power of attorney, this law that was created who knows long ago, and these documents that may have been created who knows how long ago, they didn't consider this thing called a digital asset. So on September 13th in New Jersey, Governor Christie signed legislation which is known as the Uniform Fiduciary Access to Digital Assets Act, or what we like to call YFIDIA. No, actually, I have no idea what we call it, but New Jersey joined about 23 other states which have already enacted some version of that law. And basically, the law recognizes a fiduciary's heir to control digital assets, and the fiduciary power also extends to disability. So whether you've passed away or you have become incapacitated, there's a definition for what digital assets are. And so they include things like their online bank accounts, their email accounts, their social media accounts, computer files that might be on there. One of the biggest services out there where we hold information is Dropbox. A lot of people have Dropbox accounts because they're free and up to 2 gigabytes of storage, or Evernote. People take a lot of photographs and post things up on Evernote. Well, how do we get access to that stuff if you become incapacitated? Well, without this law that basically orders these companies to allow a properly designated fiduciary to access them, they just kind of wither. So we're going to cover things like data and text and images and video and codes and computer programs and databases and currency even. I mean, a big thing now is people owning Bitcoin and, and some of the other digital cryptocurrencies that are out there. So in any event, this law basically allows that. Now, it does restrict the fiduciary's access to certain kinds of electronic communication, like email, text messages, unless the person has consented to it in the will, the trust, or power of attorney. So what does that mean? What does all of that jumbled together mean? It means you really need to update your estate plan because this law, while it grants access, only does so if the person who is seeking access has some paperwork that says that they've granted this authority to somebody else. So if you have old paperwork that doesn't grant access to digital assets in some fashion, then it doesn't matter. The power of attorney is not going to be honored there. So we need to update that. Now, it does cover different kinds of fiduciaries. Now, fiduciaries, remember, those are the people that stand in your shoes that are supposed to put your best interests ahead of their own. They're your agents in there. And we have fiduciaries in the investment world, and I'm a fiduciary when it comes to handling my clients' information, both on the legal side and the financial side. But in this context, the fiduciary is really like an executor of your estate, a court-appointed guardian. Now, remember, if you're listening to me, you have a good power of attorney and you're avoiding a guardianship, but lots of people don't. So the court-appointed guardian, agents under a power of attorney, and trustees. And that's basically the people that are governed under this in terms of the definition of the fiduciaries. And by the way, you still have all of the same responsibilities. So you don't get any less responsibility over these assets simply because they're digital assets. So essentially what that means is that if you're going to have control over this stuff, you essentially have to make sure that you are managing them for your principal's best interest, right? So that's basically, doesn't change anything. Whether you're talking about money, your social media accounts, whatever it is, you're responsible, and you're responsible to do that the right way. So that just came into law. It actually takes 90 days to take effect. So if you become incapacitated between now and 90 days from September 13th, that you can't rely on this law. But after that period of time, it's then deemed effective. So if you have not already, you should review your power of attorney because it may not include provisions for digital assets. Now, I've been including digital assets provisions for years in the power of attorney form that we have. I'm going to have to review that now with this new law to make sure I've covered everything. But you definitely want to update at minimum your power of attorney, your trust, if you have a trust, your will, and make sure the will is clear about access to digital assets, and make sure that altogether you have the right documents that when you pass away, the people who are going to try to help you after you're gone have the ability to manage everything, including your super important Instagram account. I make light, but it is important. All right, listen, when we come back from the break, I'm going to talk to you a little bit about how to protect the inheritance. And that's a really important topic because a lot of people want to make sure that what they leave behind go to the people that they want, the way they want them to have it with no threats. So join us when we come back on Make It Last, where we help you keep your legal ducks in a row and your nest egg secure. We'll be right back.
Just about every working American stays focused on the ultimate goal, retirement. But planning for it can come with a lot of uncertainty. Do I have adequate savings? Have I invested enough? Have I invested too much? What's the right thing to do? If you're one of the millions of Americans asking these questions, let financial expert Victor Medina help you make sense of it all. Victor is a certified financial planner and retirement income specialist who can help you set the strategy with a unique planning process that centers on you. By taking an in-depth look at your retirement timeline, goals you want to achieve, and what you have saved, Victor and his staff can help you figure out how to get the most out of retirement. Retirement is the biggest financial decision you will make. Putting the right plan in place and sticking to it is the smartest decision anyone can ever make. To learn more, visit Private Client Capital Group online at privateclientcapitalgroup.com and start down the path of securing your total wealth today.
Welcome back, everybody. So today we're going to talk about asset protection. And as I said before, it's one of those topics that is really at the core of how and why people do their estate planning. When I meet with them, they certainly want to make sure that there is an orderly transition from one generation to the next. They want to make sure that things are in order, their ducks are in a row, and that there are no hiccups along the way. But when we get down to the next level, say, okay, everything's lined up, what's important to you? Well, it turns out that one of the things that's important to them is to make sure that the stuff that they leave behind is protected. Now, when I do this show, as you longtime listeners will know, try to take the second segment and talk about the academics and the theory behind whatever I'm trying to teach today. And then in the third segment, I tell you practically about how to get that done. So I'm going to take this segment and talk a little bit about asset protection and what it means, how it's created, and then we'll end up in the last segment talking about how to make sure that you have it in your plan. Now, asset protection has a few elements of it. One of them is control. And the other one is, whether it's accessible by somebody else. Okay, so there's two different levers that you have with asset protection. One is your ability to control something and somebody else's ability to attack it. And when you think about asset protection from that context, it's really difficult for you to create asset protection around your own assets. If you're under threat from something on the outside, most of the time it's too late to do anything with asset protection. We had a call in the office the other day, and the person said, "I have to come in and see you this week." And we say, "Well, why?" He says, "Well, I'm getting sued and I need to protect my assets." We're like, "Click, it's too late. Sorry, this is something that you do beforehand. You can't protect them after the threat's already there." And it's already difficult enough to get that done because what we call self-settled, the ability for you to protect your own assets, that's really tough. That's really tough for you to do. So it's much easier for you to protect it when you leave it behind for somebody else. When you're protecting it on your own assets, and we've done this from time to time for some clients, many times what you have to do is you have to move those assets overseas. It's one of the reasons why we develop relationships with overseas investment advisors, and why we know a little bit about how to create entities in offshore islands and things like that, because it turns out that that's one of the ways that you're able to protect things on your own. But look at all of the headache that you have to go through in order to do that. You literally have to move assets overseas. You have to create these offshore accounts. And, we're not hiding money from taxes. Everybody still pays the taxes on it, but we're making it really super difficult for somebody that wants to bring a claim against their clients to locate these assets and to have an enforceable judgment against them because of the laws of where these trusts and LLCs are located. So super hard to do that with your own money. Super easy to do that with the right estate planning when you leave that money behind. Because when you leave that money behind, you're able to create terms around who can access it and for what reason. So when you think about how to leave something behind, most people leave things behind what I call outright. That's a legal term, but they just basically write a check to somebody, and then the person can deposit that account in there, and that is unprotected. You basically just handed them a bag of money, and that bag of money can be attacked. That bag of money can be mismanaged. So asset protection can also mean protecting somebody from themselves, but it also can just be attacked from the outside because there's no walls of protection around it. Now, as many of you know, I've written 2 books. One of the books is on the legal side, and we call it Make It Last, how to get and keep your legal ducks in a row. One of the chapters in there is what we call inheritance castles. So we think about what we leave behind as having been left inside of a castle that's created for your kids. And these inheritance castles are very, very strong. So rather than handing them a bag of cash, what we did is we created a castle, and the cash is inside the castle. The home that you're leaving behind is inside the castle. And the castle metaphor holds up pretty well because, as you know, a castle is insulated from attack, right? Really thick walls. And so it means that the assets that are inside of the castle end up being protected because of the structure that's around that. Now, the real technical term around an inheritance castle is a subtrust, or a form of a trust that's left behind. And we're creating an entity that has some rules around it, and because the rules say that we can't move money out of the castle except in certain circumstances, those assets remain protected for the person. And when we set up the castle, we can ask the question, should we leave your kids in charge of the castle? For most of our clients, the answer is yes. It's okay for us to do that because, in fact, they're fine to manage that. And then other times they'll say no, they shouldn't be held in charge. And a couple of different guideposts for that. Like if your kids are really young, probably not super good idea to leave them in charge of the castle when they turn 18. And you might want to extend that a little bit further. You might want them to have a companion. So we'll talk about that in the next segment about how to actually set it up. But the idea is that in the planning that you do, you have set some terms on what you've left behind. And because you can set basically any terms that you want, you can determine how thick the walls of the castle are, who gets to control it, and the protections are very, very strong. And those protections not only extend to what you've left in one generation, but how those assets pass down in future generations. So one of the biggest things that people want to make sure happens in their estate plan is that the money that they leave behind is left for the benefit of their children. And then when their children are done with it, if their children pass away and there's still money left over, they want to make sure that that money goes to their grandkids without without any interruption, without any threat. So they'll say to me, it's fine for it to go to my daughter, but I don't want it to go to my son-in-law for whatever reason. So I want that to go to my grandkids. And if my grandkids, or if I don't have any grandkids, I want to go to my other children. And so we call that bloodline or heritage protection, where what we're doing is making sure that these assets pass down from the one generation to the next. And we can do that in the planning that we create for them, because you can basically dictate any terms you want around the assets that you have left behind. It's your money. You can choose to leave it to whoever you want, and you can choose to leave it to them however you want them to have it. Now, you've created these protections, right? And then the question becomes, do they hold up, or how do they hold up? Well, in many cases, they hold up because of the rules that you have set in place for how money comes out. So if you said, look, I want to leave this behind in this inheritance castle, and I want to make sure that this stuff is protected, one of the questions that you'll have to answer is, well, how can money come out? And if you said that the money can only come out for the health, education, and maintenance of the person who's the beneficiary of that trust. So I'm leaving it behind in an inheritance council for my daughter, and the money can only come out for the health, education, and maintenance of my daughter. That means when there's an attack from the outside, like a judgment creditor or a divorce, they're not going to be able to pierce that veil or that shield because it doesn't meet the test. Doesn't meet the test for how assets are supposed to come out. So you have to go ahead and structure that the right way. You're going to have to write the terms so that you have narrowly written out what's supposed to happen. That this only happens in certain circumstances. Now, there's some rules whether or not you put your kid in charge of their own trust, or if you have somebody on the outside, you can create stronger protections. If you have somebody on the outside managing the terms of how the money comes out, we call it a discretionary trust. So you can go ahead and say, look, I'm leaving this behind, but I'm going to have a completely separate third party be the person that determines when it comes out at their discretion. Well, that's actually the strongest protection, as long as that person who's making the decision is not the beneficiary, as long as we've separated that out. So you can determine how and when that happens, but the test comes because the terms that you have set are narrow enough not to cover whatever the judgment is going on, whether the divorce or the creditor or whatever else is going on. So that's the way those two things kind of work together. Now, when we come back, I will talk to you about how to examine your own estate planning to make sure that you have these protections in place, because many of you think you do, and you don't. And I'm going to have to let you know that, and I'm going to tell you how you have to fix it. So stick with us. When we come back, I'll make a last one. When we come back in the next segment, I'm going to talk to you about how to examine that, and we're going to fix it. So stick with us. We'll be right back after the break.
As you get older, there are so many decisions to make around your legal, financial, and tax planning needs. Searching for the right people who you can trust and getting them all on the same page can be frustrating and exhausting. Turns out, now there's a better way. Medina Law Group is the only place where you can secure your total wealth with a one-stop shop for your estate, retirement, and tax planning needs. With over 15 years of experience and more financial credentials than you can shake a stick at, Victor Medina and his team offer a way to cover all of your planning needs under one roof. Whether you're concerned about getting your ducks in a row or securing your nest egg or both, Medina Law Group can give you the peace of mind you deserve to make sure you have all the angles covered with best-in-class planning. Call the experienced professionals at Medina Law Group at 609-818-0068 to learn more, including your chance to schedule a free consultation. You can also visit MedinaLawGroup.com to learn more about protecting your assets and the Medina Law Group team. For peace of mind and a solid foundation, contact Medina Law Group today.
Okay, welcome back, everybody. So we've been talking a little bit about asset protection, and I can't tell you how much I love doing this show, because I got to get this done for you in 30 minutes, and you just got a crash course on asset protection in segment 2 that normally takes like 3 hours when I train CPAs and other advisors on it, even the lawyers from time to time. And so you got it in 9 minutes. So I hope you were paying attention, because now we're going to transition and talk about how to make sure that what you have in place, your estate planning, actually meets some of these asset protection principles. Now, we're talking about death planning in this case. So we're going to set aside the concepts of powers of attorney and advanced healthcare directives. They have no place right now. We're actually going to focus on wills and trusts, because these are protections that in your own lives will actually materialize after you're gone. So I'm so sorry that you put this whole estate plan together. You are never going to see whether or not it's worked. You'll be gone. Okay. But if it's set up the right way, it will work, and you have to check on these things. Now, there's two different ways that we can set up these protections. We can set it up from within a will, or we can set it up from within a trust. Now, my clients know which preference that I have, which is whenever possible, use a trust, because the trust has benefits over the will, and those benefits include privacy, the ability to manage the assets when you're disabled, the ability to make changes without a lot of the kind of pomp and formality that happens around a will. And the other reason is that because the will only becomes effective if you probate it, it's hard to lose the trust if somebody doesn't like the terms of it. So think about a little bit more devious mind. If there exists a will that creates all these protections, and it turns out one of your kids, doesn't like those protections, and then conveniently loses the will, well, they're still going to get their third if they're one of three kids, but they don't have to worry about those terms on there. So the will only becomes effective if we probate it, and so I tend not to like the will. It doesn't matter about length. At the end of the day, they're about the same length in the documents that you have. But whether you have a 40-page will or a 40-page trust doesn't make too much of a difference in its effectiveness. But I do like the trust better because it's an immediately effective document, and you get all these privacy benefits. So now you have a will that pours into the trust. You have a trust, and it has the asset protection planning. Now, how do we make sure that it actually has the asset protection elements of it? So whether you're reviewing your will or your trust, you're going to look at the residuary or dispositive provisions. So sorry for those two kind of quarter words there, but you're looking for where you're leaving stuff to somebody else. And so if your provisions in your documents basically just say, I hereby leave this stuff to this person, and that's it, you don't have the asset protection. Because the asset protection is actually going to create that inheritance castle that I was talking about. And so you will go ahead and you will have language in there that'll say, I am going to set aside 1/3 of my assets for this person, and I want you to create a trust share to be administered this way. And so you'll set there that all of the income gets paid out, that they have access to principal for their health, education, and maintenance. This is all language that your lawyer is going to help you with, but it has to have that language in there that basically says, I'm creating this share for somebody, and I'm putting rules around how to distribute it. Because if all you have is a little line item that says, I'm going to leave everything to my kids in equal shares, and then we're done, it doesn't have any more rules about it, you don't have asset protection. You didn't build the inheritance castle. It takes work. You got to set the blueprints out, man. You got to get that stuff out there. So you want a little bit longer provision. This is kind of a little test to make sure that it's there. Now, in addition to making sure that it is in there as a longer paragraph, I don't know how else to say it. If you're not a lawyer, you're not going to be able to read and understand it, but you can spot whether or not you have it by basically looking at the length of the provision. So you want to make sure that you've created these trust shares, and then inside of there, you want to talk about who's in charge of it. So you want to set a trustee over the share for your kids. For most people, that's going to be the kids themselves. Most people have pretty reliable kids. It's okay for them to manage that. I say to clients all the time, is it appropriate that we give this kid the checkbook for his own account? Should we give him the ATM card and the PIN number? And for most families, the answer is going to be yes. It's totally okay to do. In some cases, you get somebody who's a threat to harm themselves with drugs or alcohol, or is a spendthrift and doesn't know how to manage money. In some cases, we might give somebody else the authority to manage this money and the distributions of this money. So we might hand the checkbook to someone else. But you're going to want a provision inside of there that not only creates the castle, but talks about who has got the keys to the castle, who is in charge of it. We call that person a trustee. By the way, we call him a trustee whether or not you start with a trust or you start with a will. So we call him a trustee in the other case, but you want to talk about who's going to be in charge. Now, don't stop there, because in addition to naming somebody who's going to be in charge, you're going to want to back up to that person, that if they become incapacitated, if they die, that we have a vice president, or we have some line of succession for who's going to be in charge. So great, we have set up this inheritance castle, and we've set somebody up in charge. The next thing we want to talk about is what happens to the assets that are inside the castle. Because depending on the size of your estate and the prudent management of these assets, could be that there's stuff left over after the person dies. So you want to talk about what's supposed to happen to those assets in that instance. So you'll think about, okay, well, if there's any money left over, should it go to my own kids? Should it go to their kids? Should it go to a charity? You're going to be able to talk about what happens to this stuff when that person dies, if there's anything left over. And so this kind of bloodline protection, heritage protection, basically where you're talking about where stuff happens afterwards, is another element to the creation of this castle, because you're going to leave the keys to the castle, and then you're going to talk about who inherits the castle after that person's gone. Now, if you have all of these elements and you have the base level of asset protection for what you leave behind for your kids, done correctly, this will protect these assets against their divorce. So if you imagine a scenario where you left behind this inheritance for your daughter and that no good son-in-law that you've got, and they have a divorce, the no good son-in-law who hires this big, expensive, fancy divorce attorney, he's going to go in and say, I want some of my in-laws' inheritance. And this trust that you've created for the benefit of your daughter is going to have rules about how money comes out. And the rules are going to say, first of all, it wasn't your daughter's money to begin with, so you don't get a cut of that. It's not like it's a marital asset. And by the way, there's some rules about how that money comes out. And one of the rules says it doesn't come out for any judgment creditors. It only comes out for the health, education, and maintenance of your daughter. And sure, we can use that money to have them pay for school and medical expenses and get them set up for a home. But I can't split that money with you. You are not a beneficiary of that money. So you, the no good son-in-law, you cannot touch this inheritance, what we leave behind. I got to tell you, folks, that's the number one reason why we put plans in place. We start talking to people about these asset shields that we can create, these inheritance castles, and it is the number one reason why people want to make sure that their assets are properly protected, because they want to enjoy it during their lifetime. They're fine with their daughter enjoying it. That can be their money. So, yep, I'm going to leave that behind for my daughter. But my daughter gets divorced, or when she dies, I don't want to go into my son-in-law. I want to go into my grandkids. And by the way, my grandkids, they might be small, and so I don't want their father to manage that. So I'm going to determine somebody else who's going to manage that money and make determinations about when it comes out. So as you can see, these are good protections to have in place, because you're properly setting up what happens to your stuff when you're gone and making sure that that stuff is saved and protected and otherwise insulated from any future attacks. So go examine your estate plan now. Drop everything that you're doing and check and make sure that you have these protections in place, if it's important for you to make sure that the stuff that you leave behind isn't threatened by some outside attack in the future, like a divorce or a creditor, or that it follows the bloodline. Okay? And then consult with your estate planning attorney about making sure that's done the right way. All right, so that wraps up the show for today. If you've liked what you've heard, do me a favor. Go on to iTunes. Search for Make It Last. You're going to see the little blue box, and it's going to say Make It Last with Victor Medina. Click on that and leave a review, a 5-star review, talking about how awesome this radio show is, this podcast. And that way, Apple will bring it up to the top when people say, I want to learn more about legal planning, retirement planning, whatever it is. And people will find this podcast, share it with your friends, send them the link, tell them to listen to WCTC 1450 AM at 7:30 in the morning on Saturdays, where they can stream it live by going to the website. They can even go to Make It Last Radio, and they can play all of the back episodes as well. We've got a whole library now. This is show, I think, 25. So we're a quarter of a century old on this. Well, quarter of something anyway. So we've got a whole library. We're going to continue going. Really happy to have our contract extended over at WCTC, and we're going to continue to be producing this radio show for you. Hope you're enjoying it. So listen, that's this topic for this day. We're going to catch you every Saturday morning. I want to thank you for joining us. This has been Make It Last, where we help you keep your legal ducks in a row and your financial nest egg secure. Catch you next time.
The foregoing content reflects the opinions of Medina Law Group, LLC, and Private Client Capital Group, LLC, and is subject to change at any time without notice. Content provided herein is for informational purposes only and should not be used or construed as investment or legal advice or a recommendation regarding the purchase or sale of any security or to follow any legal strategy. There is no guarantee that the strategies, statements, opinions, or forecasts provided herein will prove to be correct. Past performance is not a guarantee of future results. Indices are not available for direct investment. Any investor who attempts to mimic the performance of an index would incur fees and expenses, which would reduce returns. All investing involves risk, including the potential for loss of principal. There's no guarantee that any investment plan or strategy will be successful. We recommend that you consult with a professional dedicated to your needs.